Hello, and welcome to Module 4, titled Employee Benefits and Retirement Funds Advice. In this module, we will cover the following topics: requirements for rules, trustee meetings, and group retirement products, as well as law on marriages. Learning Unit 1, Retirement Funds. Retirement funds in South Africa are regulated under the Pension Funds Act of 1956. This act stipulates the requirements for the rules governing a fund. These rules dictate all the fund's functions and define various benefit categories. It is important to understand that the rules are not merely guidelines, but are legally binding on the fund, its members, shareholders, officers, and any person with claims derived from the fund. This includes dependents of the members, who must also adhere to the fund's rules. Requirements for rules. The rules of a fund applying for registration must be in the prescribed format and meet the specified requirements. Any amendments to the rules must also comply with the prescribed format and requirements. Amendment of rules. Registered retirement funds may amend their rules as specified within the existing rules. Amendments can include alterations, rescissions, or additions. However, these amendments must not affect any creditor's rights, except for members or shareholders. Changes are invalid without the approval of the Commissioner of the FSCA, and the request for approval must be submitted within 60 days of the resolution to amend the rules. If an amendment impacts the fund's financial condition, the principal officer must also submit a certificate from the valuator or a statement from the fund if no valuator has been appointed. The Commissioner will approve and register changes if they do not adversely affect the fund's financial status and are consistent with the Pension Funds Act. Consolidation of rules is also allowed, provided it does not introduce new rules or alter existing ones. Matters addressed by pension fund rules. The rules of a pension fund typically address eligibility, benefits, contributions, decision-making procedures, trustees, meetings, round-robin resolutions, fund committees, governance, etc., board of trustees, requirements for a board of trustees. Every fund must have a board of at least 4 members, with at least 50% elected by fund members. The board's composition must comply with the fund's rules. Vacancies must be filled within a prescribed period. Otherwise, the FSCA may appoint Section 26 trustees. The board members must meet prescribed skills and training requirements within 6 months of their appointment and maintain these throughout their tenure. The board must inform the Commissioner of any board member departures not related to term completion. If the board becomes aware of material circumstances that may prejudice the fund's financial viability, it must notify the registrar in writing. Exemptions. The Commissioner may grant exemptions if it is impractical or expensive to maintain a board of 4 members, provided that at least 50% of the board members are elected by the fund members. Exemptions can be withdrawn if the conditions are no longer met. Object of the board. The board's objective is to direct, control, and oversee the fund's operations in accordance with applicable laws and the fund's rules. This includes protecting members' interests, acting with due care, diligence, and good faith, avoiding conflicts of interest, acting impartially and independently, and responsibly managing the fund. Duties of the board. The board's duties include keeping proper records of fund operations and minutes of meetings, ensuring proper control systems are in place, communicating adequate and appropriate information to members and beneficiaries, ensuring timely payment of contributions, delegating functions where necessary but retaining ultimate responsibility, liability of board members. Board members can be relieved of liability by a court, except in cases of willful misconduct or breach of trust, if they have acted independently, honestly, and reasonably. Trustee meetings. Introduction. Section 7D of the PFA requires trustees to ensure proper record keeping, control systems, communication, timely contributions, and seeking expert advice. Trustee meetings, often held quarterly, are crucial for fulfilling these responsibilities. Agenda. The chair decides the agenda, which can include items from other members. Common agenda items are apologies for absence, conflicts of interest, minutes of previous meetings, matters arising from minutes, management information, employer covenant review, investment monitoring, scheme administration, communications, scheme risks, scheme costs and charges, trustee training, legal updates, any other business, documents for trustee meetings. Trustees should refer to the trust deed and rules, trustee powers and responsibilities, previous minutes, relevant policy documents, procedures like the internal dispute resolution procedure, minutes. Draft minutes are circulated after meetings and approved at the next meeting. Learning Unit 2, distribution of pension benefits. Pension wealth distribution in South Africa is regulated by the Pension Funds Act. Unlike other personal assets, there are specific guidelines on how pension benefits are treated in various circumstances, such as death, disability, divorce, and maintenance obligations of a member. Additionally, there are circumstances where the fund may or may not make certain deductions from pension benefits. This unit explores the treatment of pension benefits under these circumstances. Pension benefits, restrictions on reduction, transfer, or execution. Under the Pension Funds Act, benefits provided by a registered fund, rights to such benefits, or contributions made on behalf of a member are protected against reduction, transfer, cession, pledge, hypothecation, attachment, or execution under court judgment. Exceptions are made only to the extent permitted by the PFA, the Income Tax Act of 1962, and the Maintenance Act of 1998. If a member or beneficiary attempts to cede, transfer, or pledge their benefit, the fund may withhold or suspend payment. The fund can also pay the benefit to the member's dependents, guardians, or trustees, as deemed equitable. Specific deductions permitted. Debts. Due to the fund. Amounts owed by the member to the fund for arrear contributions or loans, excluding employer's failure to pay deducted contributions, can be deducted. Payment to third parties. If a member or beneficiary cannot open a bank account, the benefit may be directed to a third party upon sufficient proof. Insolvency. Pension benefits, including annuities, do not form part of an insolvent estate and are protected from creditors. Disposition of pension benefits upon death. Upon a member's death, benefits are distributed according to the PFA rather than forming part of the estate, except for certain pensions payable to spouses or children. The benefits are distributed as follows. To dependents, within 12 months, the fund pays dependents directly or in proportions as deemed equitable. To nominees, if no dependents are found within 12 months and the member designated a non-dependent nominee, the benefit is paid to the nominee. Combination of dependents and nominees. If there are both dependents and nominees, the fund distributes the benefits proportionally as deemed equitable. No dependents or nominees. If neither dependents nor nominees are found within 12 months, the benefit is paid into the member's estate or the guardian's fund, if no estate inventory is available. Payment mechanisms. Payments to dependents or nominees can be made to trustees or persons legally responsible for managing the affairs of the beneficiaries. Benefits for minors or major dependents unable to manage their affairs may be paid in installments with accrued interest. Agreements for installment payments to major dependents must be documented and can be terminated with notice. Deductions due to divorce. Under the Divorce Act of 1979, a portion of the member's pension interest assigned to a non-member spouse in a divorce or customary marriage dissolution is deemed to accrue on the decree date. The fund must deduct this amount upon receiving the court order from the non-member spouse and can pay the amount directly to the non-member spouse, transfer the amount to another pension fund on behalf of the non-member spouse. The non-member spouse must be notified within 45 days and provide their election within 120 days. If they fail to do so, the fund retains the amount until payment instructions are provided. The non-member spouse accrues fund returns on the amount until payment. Permissible deductions from pension benefits. A registered fund may make the following deductions from a member's benefit: income tax, amounts due under the Income Tax Act of 1962, loans and guarantees, amounts due for loans granted to the member or guaranteed by the fund, employer loans, amounts due to the employer for loans or guarantees, limited to lump sum benefits under the Income Tax Act. Compensation, amounts for damages caused by theft, dishonesty, fraud, or misconduct by the member, including legal costs. Learning Unit 3. Group Retirement Products. Types of retirement funds. Pension fund. Under a pension fund, a maximum of 1/3 of the fund benefit can be taken as a lump sum in cash upon retirement. The remaining 2/3 must be paid as a pension for the rest of the pensioner's life, subject to a statutory minimum. If the total benefit is below the set minimum, it can be taken as a cash lump sum. Provident fund. With a provident fund, members can take the full fund credit as a lump sum at retirement. Members also have the option to purchase an annuity with their lump sum if they choose. Preservation fund. A preservation fund is a type of pension or provident fund where a member's withdrawal benefits can be transferred after exiting employment. The fund preserves the accrued benefits tax-free until the member reaches retirement age. The invested amount continues to earn interest, but no additional contributions are typically allowed. Pension funds, provident funds, and retirement annuities. Pension fund. A pension fund, in relation to any person, is a fund approved by the Commissioner as a pension fund under paragraph C of the definition of pension fund in Section 1 or a corresponding definition in any previous Income Tax Act, or a public sector fund, mainly providing for annuities on retirement to its members, if the person was a member during any such year. Provident fund. A provident fund, in relation to any person, is a fund approved by the Commissioner as a provident fund as defined in Section 1 of this Act or corresponding provisions of any previous Income Tax Act, or b. a public sector fund providing benefits in a lump sum exceeding 1/3 of the capitalized value of all benefits to its members on retirement, if the person was a member during any such year. Retirement annuity fund. A retirement annuity fund is any fund, other than a pension or provident fund, approved by the Commissioner and registered under the Pension Funds Act if established on or after July 1st, 1986. The Commissioner must be satisfied that a member discontinuing contributions before retirement is entitled to a. an annuity or lump sum benefit as per the second schedule, b. reinstatement as a full member under fund rules, c. a lump sum benefit if the member's interest is below a set amount or if the member emigrated and this is recognised by the South African Reserve Bank for exchange control. Further conditions include no surrender, commutation, assignment, or pledging of benefits as loan security, notification of all rule amendments to the Commissioner, compliance with fund rules, comparison of retirement fund products, fund advantages, disadvantages and risk affordability, future needs of members, pension fund benefits preserved, annuitization, portability upon resignation, annuities may run out, poor returns possible, depends on fund rules, member income, employer contributions, dependent on accumulation, longevity risk, economic changes, provident fund benefits received before inflation erodes value, portability upon resignation, lump sums may be consumed without annuitization, depends on fund rules, member income, employer contributions, NA, retirement annuity enhances, provident or pension fund benefits, tax benefits, independent of employment, no employer contributions, exit restrictions before 55, depends on fund rules, member income, NA, products according to benefits and tax implications, fund type tax deduction limits, pension fund. The deduction allowed is the sum of pension, provident, and retirement annuity fund contributions, limited to the lesser of 27.5% of the greater of remuneration or taxable income, or R350,000. Employer contributions, Section 11K of the Income Tax Act. Taxation on withdrawal from a pension fund, 2020 tax year. Funding methods. Standalone funds. Standalone funds are designed for a specific group of employees of a particular employer with benefits, management, costs, and investments all managed at the fund level. Suitable for larger groups due to economies of scale, smaller groups may find the cost too high. Insured funds. Insured funds operate via an insurance contract between the insurer and the trustees acting on behalf of the fund and its members, often managed through deposit administration, these funds offer less flexibility for smaller funds. Trustees are ultimately responsible for management and investment strategies. Umbrella funds. Umbrella funds, often used to reduce administration costs for smaller funds, allow employers to join a larger fund. These funds usually offer defined contribution structures and are marketed through insurers or large brokerages. Group risk-benefit options. Group life insurance. Group life insurance provides coverage to employees or members of clubs or organizations as a benefit. It includes various types of cover. Group life cover pays a benefit upon the insured's death, which can be a multiple of salary, a fixed amount, or a balance on a mortgage. The benefit can be used to buy a pension or taken as a lump sum upon retirement. Certain conditions, such as war or riot, may exclude coverage. Group funeral cover provides a benefit for funeral costs, often subject to a waiting period for dependents and capped at a specific amount, such as R10,000. Group capital disability offers benefits for permanent disabilities without individual underwriting. Payments may be made in installments, and the level of disability is assessed by medical experts. Permanent health insurance provides temporary disability coverage, paying up to 75% of the member's salary after a waiting period of 1 to 12 months. Coverage usually lasts up to 24 months but can extend if the member finds other employment. Dread disease cover pays a benefit upon diagnosis of serious illnesses like cancer, heart attacks, or strokes. The benefit can be a fixed sum, multiple of salary, or an amount equal to outstanding debts. Free cover limits. Free cover limits help cap benefits and reduce discrepancies. They vary based on the number of members and average sum insured, with restrictions applied to ensure fairness and manage risk. Compulsory membership ensures risk is spread across all members, reducing the impact of high-risk individuals. Voluntary membership can lead to anti-selection, where only high-risk individuals opt in. Exclusions under group life insurance. Group life insurance excludes coverage for deliberate unlawful acts, suicide, intentional self-inflicted injury, non-prescribed medication use, and high-risk activities like extreme sports and professional combat sports. Structure of group life cover. Minimum service. Life cover should start immediately upon employment, while retirement benefits may have a waiting period to mitigate early exit costs. Age. There are maximum ages for new members to join, typically aligned with retirement ages. Employee category. Death benefits can vary by employee category, such as executives versus, non-executives or those with versus. Without dependents. Salary. Death benefits are often based on a multiple of salary, with all components of compensation clearly defined to avoid disputes. This structure helps ensure that all members receive fair and adequate coverage while managing the risk and cost to the insurance provider. Examples of group life risk cover marketed in South Africa. Group cover types and descriptions. Life insurance provides a sum insured upon a member's death. Lump sum disability pays a sum based on the percentage of disability. Funeral cover covers funeral expenses for the member, spouse, and children. Income disability provides income for occupational disability, preventing normal or alternative employment. Temporary disability income pays monthly income to an employee who is continuously and totally disabled until recovery, death, benefit cessation date, or receipt of retirement benefits. Spouse lump sum disability covers occupational or functional impairment of spouses. Managed income disability provides monthly income for functional impairment until recovery, death, benefit cessation date, or retirement benefits. Critical illness pays upon diagnosis of life-threatening diseases like cancer, HIV, heart attacks, stroke, etc. Accident cover pays upon accidental death or disability. Marketing of group insurance products. Distribution channels. Online distribution, marketing, selling, transacting, and processing claims through online platforms, allowing customers to compare products. Business to business, targeting decision makers in retirement funds, focusing on suitable products for employees. Benefit consultants, acting as the face of the organization, presenting different benefits provided by insurers. Tenders and quotes. Factors considered in quotations. Underwriter reputation, experience, and capacity. Number of members. Larger groups can receive more generous benefits. Total annual salaries. Basis for premium calculation, with a clear definition of what constitutes salaries. Gross premium per month, analyzed in light of benefits and policy restrictions. Free cover limit. Based on the number of employees, higher limits may increase costs. Premium as percent of payroll, important for cost comparison. Commission and administration costs, clear indicator of the fund's cost. Legislation of group life insurance. Relevant legislation. Long-Term Insurance Act defines key terms and provides a legal framework for long-term insurers. Income Tax Act addresses taxation of benefits and tax deductibility of contributions. Financial Intelligence Center Act counteracts money laundering and terrorist financing. Financial Advisory and Intermediary Services Act regulates the provision of financial services, setting requirements for financial services providers. Group termination benefit options. Withdrawal reasons and impact. Death benefits. Pension funds allow 1/3 of benefits as a lump sum and the rest as compulsory annuities, with exceptions for smaller benefit amounts. Retirement and death benefits or severance benefits. Taxation of retirement or death benefits varies based on the type of fund, pension, or provident. Early retirement, defined by fund rules and employment contracts, with penalties for voluntary early retirement and different treatments for involuntary reasons like retrenchment or disability. This summary outlines the key elements of group life risk cover options, marketing channels, tender and quote considerations, relevant legislation, and termination benefit options in South Africa. Termination benefits. Different withdrawal reasons like death, disability, retrenchment, and retirement are outlined. Pension funds and provident funds are explained, with differences in lump sum allowances and tax implications. Taxation on retirement benefits. The tax rates for retirement benefits are provided, illustrating how pension funds and provident funds are taxed differently based on lump sum amounts. Early retirement. Factors influencing early retirement, such as fund rules and employment contracts, are discussed. Tax implications and penalties for early retirement are explained, along with considerations for preservation funds. Annuities. Types of annuities are outlined, including immediate, guaranteed, deferred, reversionary, with profit, temporary, escalating, equity-linked, joint life, and survivor annuities. Factors affecting annuity pricing and tax exemptions are also discussed. Death benefits. Different death benefits available under pension funds, including pension fund death benefits and group life cover, are explained. Tax treatment for death benefits is outlined, along with distribution guidelines. Funeral cover. Some pension funds offer funeral cover for members, spouses, and children. This additional benefit may increase contributions for both employers and employees, but provides liquidity for funeral expenses, preventing diversion of pension benefits. Spouse and children's benefits. Pension funds may include pensions for spouses and children based on a percentage of the member's salary at the time of death. Children's benefits typically cease at a certain age or based on fund rules. These benefits may also be purchased separately from an insurer to reduce the fund's financial burden. Disability benefits. Pension funds provide permanent disability benefits with payments based on the level of assessed disability. Temporary disability benefits may also be provided, typically limited to 75% of the member's pre-disability income until recovery, death, or retirement age. Preservation of benefits. Members leaving a fund earlier than the normal retirement age have options such as waiting to access benefits, transferring to another fund, or taking a cash lump sum. Legislation dictates minimum benefits and tax treatment, with preservation funds offering options for continued growth of retirement benefits. Continuation options. Members leaving a fund may not be able to transfer group life and other ancillary benefits. They may convert group risk benefits to individual risk benefits within a certain timeframe, subject to insurer conditions. Regulations ensure minimum values and address charges related to discontinuance of contributions. Learning Unit 5. Marriage, Divorce, and Maintenance. Legal Insights. 5.0 Types of Marriages. South Africa recognizes various marriage regimes, each governed by specific legislation such as the Marriages Act, Civil Unions Act, Matrimonial Property Act, and the Constitution. 5.1. Marriage out of community of property. In this type of marriage, spouses maintain separate estates, excluding assets and liabilities acquired before marriage. The marriage may include or exclude the accrual system. 5.2. Accrual system. The accrual system, governed by antenuptial contracts, dictates the redistribution of assets upon marriage dissolution. The spouse with a lesser accrual claims against the other's estate. 5.3. Accrual of estate. Accrual is the net value increase of an estate from marriage commencement to dissolution. Certain exclusions apply, and proof of estate values must be provided within 6 months. 5.4. Marriages in community of property. Spouses in such marriages share equal powers over the joint estate, subject to certain restrictions on individual actions without spousal consent. 5.5. Customary marriage. Based on indigenous customs, customary marriages require registration for legal recognition, allowing for polygamy and treated as marriages in community of property post-recognition of Customary Marriages Act. 5.6. Common law marriage. While South Africa does not recognize common law marriages, certain domestic arrangements may confer partnership status, entailing joint asset ownership. 5.7. Civil unions. Civil unions, open to same-sex partners, are legally equivalent to marriages, with all relevant legal consequences and protections. 5.8. Legal consequences of civil union. Civil unions enjoy similar legal protections and obligations as marriages under various laws, including divorce and property rights. 5.9. Muslim marriage. While not yet legally recognized, precedent exists for Muslim spouses to claim maintenance and inheritance rights based on court decisions. 5.1. Zero marriages not recognized. Certain marriages, such as Hindu, Tamil, Chinese, and foreign marriages by South African citizens, are not recognized, impacting spousal identification for death benefits. 5.11. Implications of marriages on pension funds. Marriage type influences pension distribution upon death or divorce, with provisions for spousal entitlements and maintenance deductions. 5.12. Maintenance payments. Pension funds can be garnished for maintenance payments owed, including both arrears and future maintenance claims, subject to court orders and tax implications. By understanding the legal frameworks governing marriage, divorce, and maintenance in South Africa, individuals can navigate these matters with clarity and assurance of their rights and obligations. Investment strategy. The need for an investment strategy. An investment strategy serves several crucial purposes. Providing guidance. It offers a philosophy for fund managers and beneficiaries. Setting objectives. It outlines the fund's goals and risk tolerance. Manager selection criteria. It defines how managers are chosen, paid, and replaced in line with the fund's objectives. Communication. It communicates the strategy for evaluation and transparency. Role clarification. It identifies roles in the investment process and sets expectations for each. Factors. Influencing investment strategy. Considerations for investment strategy differ between defined benefit and defined contribution funds. Defined benefit. Factors include planned increases, salary adjustments, member obligations, and ancillary benefits. Defined contribution. Considerations involve member needs, risk tolerance, investment options, and default portfolios. Understanding member profiles is essential, with risk and liquidity becoming more critical for members nearing retirement. Consequences of inadequate information. Failure to gather relevant information for an investment strategy can lead to suboptimal strategies, failure to meet obligations, regulatory non-compliance, insolvency, loss of benefits for members, impacting post-retirement living standards. Issues addressed in investment strategy. An investment strategy must address various aspects, including investment legislation, prescribed assets, and regulatory compliance. Investment in current legislation. Regulations like South Africa's Regulation 28 aim to protect pension funds by setting limits on asset investments to mitigate risks. Default investment portfolios. For defined contribution funds, default portfolios must be appropriate, communicated transparently, and regularly reviewed to ensure compliance. Default preservation and portability. Rules must ensure fair treatment for members leaving employment, including provisions for paid-up membership, fair administration fees, and portability of benefits. Overall, an effective investment strategy is vital for safeguarding retirement funds, ensuring members' financial security, and meeting regulatory requirements. Annuity strategy, establishment, and compliance. Boards of pension, preservation, and retirement annuity funds must establish an annuity strategy. This strategy should be appropriate and suitable for the enrolled members, with clear communication of objectives, asset class composition, and performance to members. Living annuities. Living annuities, whether paid directly from the fund, through a fund-owned policy, or sourced externally, must adhere to certain standards. These include limiting investment choices, compliance with regulations, and monitoring drawdown rates for sustainability. In-fund and out-of-fund annuities. Both in-fund and out-of-fund annuities can be part of the annuity strategy, subject to regulatory conditions and compliance. Exemptions. The registrar may grant exemptions from default regulations upon written application by a fund, subject to prescribed conditions. Monitoring and review. Investment performance. Trustees are responsible for monitoring investment performance, whether managed internally or externally. Performance directly impacts members' benefits and the fund's long-term sustainability. Measurement of investment performance. Traditionally, investment surveys focus on nominal returns, but there's increasing recognition of the importance of measuring risk or volatility alongside returns. Common risk measures include standard deviation and return per unit of risk. Appointment of investment manager. The selection of an investment manager is critical and should consider factors such as past performance, market conditions, and compatibility with the fund's objectives. Independent advice and surveys can assist in the selection process. Investment management agreement. An investment management agreement formalizes the relationship between trustees and investment managers, regulating liability and ensuring prudence. CRISA principles. The 5 key principles of CRISA include incorporating sustainability considerations into investment analysis, demonstrating ownership responsibilities, promoting collaboration, managing conflicts of interest, and ensuring transparency through disclosure of policies and application of CRISA principles. Trustees must ensure that investment managers adhere to these principles and integrate sustainability considerations into investment decisions. Learning Unit 7, the Pension Funds Act, PFA, Evaluation and Governance. Purpose of the Act. The Pension Funds Act, PFA, aims to regulate the registration, incorporation, regulation, and dissolution of pension funds and related matters. Objectives of the Act. To provide for the registration, incorporation, regulation, and dissolution of pension funds. To ensure compliance with prescribed requirements for pension fund operations. To safeguard the interests of members and ensure the public interest is served. Registration of pension funds. Every pension fund must apply to the registrar for registration under the Act before commencing pension fund business. The registrar may request additional information or verification from the pension fund during the application process. Failure to furnish or verify information within 60 days may result in the application lapsing. Provisional registration is valid for 5 years and may be renewed for up to 5 years in total. Upon compliance with all requirements, provisional registration is converted to final registration. State contribution to pension funds. Pension funds to which the state contributes financially may require a management board. Regulations may be made to govern the registration of state pension funds. Upon registration, a pension fund becomes a juristic person, and its assets and liabilities are unaffected by registration. Asset transfer and registration effects. Upon registration, a pension fund becomes a juristic person capable of suing and being sued. All assets, rights, liabilities, and obligations of the fund are transferred to it upon registration. Assets may be kept in the name of the pension fund or approved institutions' persons. Allocation of assets and liabilities. The registrar may determine the apportionment of assets, rights, liabilities, and obligations between the fund and associated businesses. Proposals for allocation must be submitted within a specified timeframe and may be subject to public consultation. Appointment of evaluator. Registered funds requiring financial investigation must appoint evaluator. The valuator must be a resident natural person in the Republic of South Africa. Valuation process. The valuation assesses the fund's ability to meet its obligations and future funding requirements. Triennial detailed valuations are required by the PFA, although more frequent valuations may be conducted. Valuations inform decisions on solvency, contribution rates, benefit adjustments, and fund mergers or wind-ups. The valuation process. Intention of evaluation. Ensuring commitment. Evaluate if the fund can fulfill its liabilities as per its rules. Projection analysis. Assess future contributions and growth adequacy for meeting future liabilities. Key checks. Determine current asset value, future liabilities, solvency, and future funding rates. Guidelines and frequency. Triennial valuations required by the PFA, but funds may conduct more frequent valuations. Reasons for valuations: regular solvency tests, actuarial guidance, funding rate determination, rule compliance, mergers, wind-ups, and benefit adjustments. Purpose of valuation: defined benefit funds, compliance, solvency, trend analysis, funding levels, surplus release, merger implications, investment strategy, benefit adjustments, and equitable member shares. Defined contribution funds, compliance, growth allocation, excess fund allocation, benefit level changes, investment strategy, reserve account allocation, and merger implications. Assumptions. Investigation of past experience. Evaluate past fund performance for deviations, insights for assumptions, surplus strain identification, and investment manager assessment. Setting assumptions. Economic and demographic assumptions guide the valuation process. Economic: interest rates, inflation, salary and pension increase rates, investment returns. Demographic: mortality, withdrawal, early retirement, salary increase, family statistics, disability, death after retirement, new entrant rates. Data requirements: trust deed and rules, fund accounts, previous valuation report, membership details, computer-readable member information, annuity details. Socioeconomic factors. Longevity impact. Longer lifespans affect payout duration and accumulation. Contribution rates. Impact benefit accumulation. Higher rates lead to higher benefits. IIV aids. Impact. Higher exits may risk fund solvency. Labor market changes. Unionization. Contract-based employment and cost-to-company packages affect liabilities and contribution rates. To enhance clarity and organization, let's restructure and summarize the steps in the valuation process. Requirements of trustees. Every fund must have a board with a minimum of 4 members, with at least 50% elected by fund members. Board composition, election procedures, and governance details are outlined in the fund's rules. Board members must attain and maintain prescribed levels of skills and training. Responsibilities include timely reporting to the registrar on matters affecting the fund's financial viability. Duties and responsibilities of the board. Maintain accurate records, including minutes of board resolutions. Implement effective control systems and ensure proper communication with fund members. Ensure timely contribution payments and compliance with relevant laws. Seek expert advice when needed and ensure overall compliance with regulatory requirements. Liability of board members. Board members may be relieved of liability by the court if they acted independently, honestly, and reasonably. Role of principal officer. Every registered fund must have a principal officer with clear responsibilities outlined. Delegation of functions is permitted but does not absolve the principal officer of responsibility. Role of registrar. The registrar oversees the regulation of pension funds, including registration, approval of rules, valuations, and inspections. Roles and duties of administrator. Administrators must be approved by the registrar and comply with prescribed conditions. Administrator responsibilities. Administrators cannot dispose of fund information without fund consent and must maintain it orderly. Registrar must inform administrators and fund boards of proposed suspension or withdrawal, providing a chance to respond. The registrar may announce suspensions or withdrawals if deemed in the public interest. Administrators must promptly inform the registrar of any matter prejudicing the fund or its members. Role of Pensions Funds Adjudicator. The Ombud scheme is designated as a statutory scheme under the Financial Sector Regulation Act. Complaints can be lodged with a fund and, if unsatisfied, with the adjudicator. The adjudicator's office is established with specific qualifications for appointees. Offences and penalties are specified for misconduct during adjudication proceedings. Penalties are outlined for contraventions of the PFA, including administrative penalties imposed by the registrar. Procedures for imposing administrative penalties, including notice and appeal rights, are detailed. Use of pension fund circulars by FSCA. The Commissioner of the FSCA periodically releases circulars to offer clarity, guidance, or to supersede previous ones. It's crucial to understand that these circulars aren't mere suggestions, but must be adhered to by the concerned parties. For a comprehensive list of circulars related to pension funds, please refer to the FSCA website. Financial operations. Transfer to a preservation fund. Before preservation funds existed, individuals withdrawing from pension or provident funds or members of terminating funds had limited options: remaining a paid-up member of the employer's fund or a dormant fund, if permitted by the rules. Taking the withdrawal benefit in cash. Transferring the benefit directly to a retirement annuity fund without tax consequences, with no access to funds before age 55. To address these limitations, pension and provident preservation funds were introduced, allowing members of existing funds to transfer accumulated benefits under specific circumstances. These preservation funds are not intended for new members seeking to build retirement benefits. Liquidation of retirement. Inquiries by registrar. The registrar may request information from registered funds, approved administrators, or third parties regarding fund transactions. These entities are obligated to respond in writing within 30 days, or within an extended period allowed by the registrar. Registrar's intervention in fund management. The authority, through directives, may amend a fund's rules if it is financially unsound, violates regulatory provisions, or fails to manage itself according to regulations. The registrar can appoint members to a fund's board if necessary, overriding the fund's rules. Cancellation or suspension of registration. The registrar can cancel a fund's registration if it ceases to exist or was registered mistakenly, with or without agreement from the fund. Suspension may occur if rectification is possible. The registrar may apply to court for cancellation or suspension if a fund willfully violates regulations or if deemed necessary after investigation. Use of pension fund circulars by FSCA. The Commissioner of the FSCA periodically releases circulars to offer clarity, guidance, or to supersede previous ones. It's crucial to understand that these circulars aren't mere suggestions, but must be adhered to by the concerned parties. For a comprehensive list of circulars related to pension funds, please refer to the FSCA website. Financial operations. Transfer to a preservation fund. Before preservation funds existed, individuals withdrawing from pension or provident funds or members of terminating funds had limited options: taking the withdrawal benefit in cash, transferring the benefit directly to a retirement annuity fund without tax consequences, with no access to funds before age 55. To address these limitations, pension and provident preservation funds were introduced, allowing members of existing funds to transfer accumulated benefits under specific circumstances. These preservation funds are not intended for new members seeking to build retirement benefits. Inquiries by registrar. The registrar may request information from registered funds, approved administrators, or third parties regarding fund transactions. These entities are obligated to respond in writing within 30 days, or within an extended period allowed by the registrar. Cancellation or suspension of registration. The registrar can cancel a fund's registration if it ceases to exist or was registered mistakenly, with or without agreement from the fund. Suspension may occur if rectification is possible. The registrar may apply to court for cancellation or suspension if a fund willfully violates regulations or if deemed necessary after investigation. Voluntary dissolution of fund. Registered funds may be terminated or dissolved according to their rules. A liquidator, subject to registrar approval, manages the dissolution process. Assets are distributed per rules, with the liquidator preparing preliminary accounts for registrar approval. Interested parties can inspect and object to these accounts. Remuneration of liquidator. The registrar sets the remuneration for liquidators of terminated or dissolved funds. Adjustments may occur based on performance. Winding up by the court. If a fund is financially unsound, the registrar or creditors may apply to court for winding up. Court orders comply with the Companies Act, with modifications as necessary. The court ensures fair valuation of members' interests and benefits due. Liquidators must provide information to the registrar and report to the court. Cancellation of registration and dissolution of fund. When a court has ordered the complete winding up of a fund's business, and the registrar confirms that the winding up process is satisfactorily concluded, the registrar will proceed to cancel the fund's registration. At this point, the fund is considered dissolved. Winding up of unregistered pension fund. For unregistered pension funds, the registrar has the authority to petition the court for the sequestration or liquidation of the entity and its fund, regardless of its solvency status. The applicable legislation for this process includes the Insolvency Act of 1936, the Companies Act, the Closed Corporations Act of 1984, or the law under which the entity is incorporated. The court, in considering such an application, takes into account the necessity of the sequestration or liquidation to safeguard the interests of the members and to maintain the integrity and stability of the financial sector. The court may also stipulate the manner in which members' claims are proven and appoint a trustee or liquidator nominated by the registrar. Special provisions relating to liquidation of funds. In the liquidation process, the members of the fund are treated as deferred creditors, and their claims are settled after those of ordinary creditors. If the fund has a share capital, the liability of shareholders is determined according to the rules of the fund. Preparation for audit and submission thereof. Funds are required to undergo periodic financial evaluations, investigations by evaluator, and audit preparations. These evaluations are conducted at least once every 3 years, with reports deposited with the registrar within specified timeframes, depending on the fund's registration status and history. Utilization of surplus for benefit of members and employers. Actuarial surplus allocated to surplus accounts can be used to enhance member benefits, reduce contributions, or cover certain expenses. Employers may also utilize surplus for specified purposes, subject to certain conditions and restrictions outlined in the legislation. Overall, these regulations aim to ensure transparency, fairness, and stability in the management and dissolution of pension funds, protecting the interests of both members and employers, while maintaining financial integrity in the sector. The use of employer surplus to prevent job losses offers a strategic approach to navigating financial challenges while safeguarding employment stability. By tapping into surplus funds with the registrar's approval, employers gain access to additional capital crucial for maintaining their workforce. However, this process is carefully regulated to ensure transparency and fairness. Firstly, full disclosure of the fund's current financial standing and the proposed distribution to the employer is essential. This transparency empowers members to make informed decisions regarding their rights under the Labour Relations Act. Additionally, an independent auditor may certify the employer's need for additional capital, adding an extra layer of credibility to the request. Member participation is integral to the process. Members must have a reasonable opportunity to review and consider the proposal. Approval from at least 75% of currently employed members is required in writing, ensuring that the decision reflects the collective will of the workforce. Moreover, the necessity for job retention must be confirmed through negotiations under the Labour Relations Act, indicating a genuine need to prevent significant job losses. This requirement underscores the importance of exhausting all avenues before resorting to retrenchment. Furthermore, contributions and payments to the fund must be made promptly and accurately by the employer, as prescribed by regulations. Non-compliance may lead to personal liability for specified individuals, emphasizing the importance of adherence to regulatory requirements. Overall, the use of employer surplus to prevent job losses represents a balanced approach that prioritizes both the financial health of the fund and the well-being of the workforce. Through careful regulation and member involvement, this mechanism serves as a valuable tool in mitigating the impact of economic challenges on employment stability. Thank you for watching and see you in Module 5.